5 seconds to go. Start. What kind of safeguards exist? One cannot be forced to provide a DNA sample or other information simply because they have been arrested or detained. This is because it is a violation of their right against unreasonable searches. After Putaswamy judgment, the police have to follow this standard. In short, collection of DNA or other measurements is only permissible if it is justified and it cannot be a general practice. Similarly, when searching a database of fingerprints, DNA, or other measurements, the police officer will have to show a probable cause for this search. It cannot be based on the mood of the court or just a gut feeling. He has to demonstrate why he specifically searched the database, whether there was any other evidence, whether all other leads have been extinguished, and what is the basis of his suspicion. This bill fails because it does not provide any of these rules. In NCRB, prohibited from connecting these databases to other databases such as the Aadhaar database. Linking various databases will mean that this government can sit in Delhi and practically identify any citizen anywhere. Interlinking databases is a huge violation of citizens' right to privacy as it allows the government to identify citizens even for purposes other than crime detection. Unfortunately, this is the reason why this bill is being brought. Mr. Chairman, sir, Clause 3 of this bill allows government to not only collect finger and footprints but also physical, biological samples, behavioral attributes, and iris and retina scan. This is unbridled power in the hands of government and police. What are the chances that this will not be misused and exploited? What is included in behavioral attributes? Does it include gait and facial recognition? These technologies are very unreliable and heavily biased. It is concerning that the government is not even clearly saying what it wants to do. Similarly, sir, why are biological samples being collected? Is it not a way to bypass DNA bill and bring it through the back door? Preventive detention suspects and arrestees are not criminals. There is a presumption of innocence. On what grounds are you collecting their information? Under clause 4, you are saying that this data will be expunged if the person is discharged or acquitted. A person in preventive detention is neither charged nor convicted of any crime. How will their data be removed? We need these answers. Honorable Chairman, sir, I stand in support of the Criminal Procedure Identification Bill 2022. At the outset, I would like to quote our Honorable Prime Minister Modi. He had said, convergence of technology and the judicial system is the need of the hour. We need to go digital. The dissemination of legal knowledge to the common man will go a long way in improving the law and order situation in the country. Sir, I would like to emphasize here in this august house that the USP of Prime Minister Modi's government is its ability to keep pace with the changing times. This is a government with a new approach, with new thinking. Therefore, sir, I stand here to argue in favor of the Criminal Procedure Identification Bill 2022. We are all aware, and everybody has been saying this. At the cost of being repetitive, I would say that this is a new expanded form of the Identification of Prisoners Act 1920. We are all aware of the Act of 1920. Its objective was to facilitate the identification of criminals and suspected criminals through procurement of evidence. It talked of three kinds of measurements, three kinds of evidence: footprints, fingerprints, and of course, photographs. Sir, it is pertinent to mention here that the Law Commission, in its 87th report, candidly said that the Act of 1920 deserved amendment or replacement. It was of the view that there are only three kinds of measurements. This was a 102-year-old British law, and it was not in line with digitization and the new age technology. Sir, the obsoleteness of the law can be gauged by the fact that there has been increased crime rate in the country and marginal increments in the conviction rate. I would just like to bring in some figures from the National Crime Records Bureau. As per the NCRB reports, I would like to inform this august house that on average 7,50,000 cases have been closed by the police every year in the last 5 years due to lack of evidence. I come from Odisha, and I would definitely like to quote figures pertaining to Odisha that we got from the NCRB report. In 2020, 244% increase was registered in Odisha, alone with record to the number of cases which had been closed by the police because of lack of evidence. This figure was 38%. This percentage was just 38 in 2019. So there is a leap from 38% to 244% from 2019 to 2020. This is the NCRB report. It is because of lack of evidence the police had to close the cases. The Act of 1920 is very rigid and narrow, and therefore the need to have this particular act. Once this bill becomes an act, the Act of 1920 will stand repealed. We are not going for any amendment, we are going for replacement. We are aware of the main features of the proposed bill of 2022. I would just take 2 minutes to talk about those features. Firstly, of course, this bill seeks to define measurements to include finger impressions, palm print, footprint impressions, photographs, iris and retina scan, physical, biological samples and their analysis, behavioral attributes, etc. Secondly, it seeks to empower the NCRB to collect, store, and preserve the record of measurements. Thirdly, it seeks to empower a magistrate to direct any person to give measurements. Stop.